Okay, welcome everyone to another SIPL seminar. So I'm really happy to be able to present to you Professor Margo Bagley, who's going to talk on a sort of very interesting topic relating to the interface between intellectual property protection, genetic resources, and the idea of sort of sharing in the context of commons with regard to genetic resources. And so Margo has, worked for many years. I think, met you, Margo, many years ago in that context of already looking at genetic resources and intellectual property and patent law in particular. And just to pick one or two highlights from your really impressive bio, you've done lots of work for the African Union in the context of WIPO in relation to the CBD, and then for the FAO as well. And you've published in this context. And in fact, I think the paper you're going to be giving today also relates significantly to that particular context, namely this idea of just sharing, virtues of digital sequence information, and benefit sharing for the common good. So I'm not going to try to sort of, summarize the paper, because I think you'll be much better in doing that. So with that, I'll just hand over to you, Margo, and we'll really look forward to a great presentation. And as I think you already saw, for those who are attending, ideally, if you have questions, post them in the Q&A rather than the chat, because then other people will see them as well. We'll address them after the talk. And with that, I think just hand over to Margo. Thank you very much.
All right. Thank you so much, Henning, for that kind introduction and for the invitation to present on the topic of just sharing, the virtues of digital sequence information benefit sharing for the common good. And this is a topic that I've been working on, as Henning noted, for a number of years now. It really started with a paper I co-wrote with Hardy Cross for the Wilson Institute, the Wilson Center on Synthetic Biology and the Nagoya Protocol. And they asked us then to write another paper. Hardy had to drop out. But I started going around with folks from the Wilson Center to various Convention on Biological Diversity meetings, made contacts that led to more commission papers for the UN FAO and the UN Convention on Biological Diversity, and then began serving as a technical advisor to the African group of biodiversity negotiators on DSI matters. And all of that ultimately culminated in me wanting to write a paper outside of the constraints of the various commission papers that really laid out what I saw happening in these negotiations, particularly in relation to this issue. And so that's what I'm going to be talking about. This paper is coming out very soon in the Harvard International Law Journal, and it really lays out this whole negotiation and some of these issues that are really of importance in a number of fora. Today, I'm going to focus on the Convention on Biological Diversity, but I have here a number of international fora where DSI, digital sequence information, synthetic biology issues are being discussed and are creating challenges for some agreements that are in place and others that are being negotiated. So in terms of the Convention on Biological Diversity, it has several principles. I have the key principles here, as well as the key objectives. It states that states have sovereign control over the genetic resources within their borders, but they should endeavor to make access available on mutually agreed terms with prior informed consent, and there should be the fair and equitable sharing of benefits from the use of those genetic resources and associated traditional knowledge with the party that provides those resources. And this was against the backdrop of, at some times, genetic resources being viewed as a common heritage of mankind, free for everyone to use. And the Convention on Biological Diversity said, no, states have ownership in the sense of these resources. And then there are these objectives: the conservation of biological diversity, sustainable use of its components, and the fair and equitable sharing of the benefits arising from the use of genetic resources. And as some authors have pointed out, Schroeder and Pisapati, the idea of justice really underlies and permeates the Convention on Biological Diversity, ideas of intergenerational justice, procedural justice, international justice and exchange, that there was some unfairness in the system that, in a sense, the CBD was designed to ameliorate. One aspect of that unfairness was perceived biopiracy. And this is where you might have researchers coming to a group of indigenous peoples or local community members, learning about plants in their area that are used for particular purposes, perhaps medicinal, finding out the active ingredients, extracting that, patenting them, and not sharing the benefits with those providers of the knowledge or the country from which the genetic resources were obtained. An example is a class of hypertension drugs, ACE inhibitors, that were derived from the venom of the Brazilian pit viper, a snake found in the Amazon basin. This has led to many drugs that are very beneficial in reducing hypertension, but not benefit sharing going back to Brazil, where the venom was originally obtained and where these particular genetic resources originate. Now, the Convention on Biological Diversity was great in that it set out these objectives and requires benefit sharing, but didn't really say how it should be done. And so many years later, the parties, and they of course had been talking about this through the years, agreed to the Nagoya Protocol. Not all of the parties, but many of the parties, it's something maybe close to 130 of the 196 have signed on to the Nagoya Protocol to the CBD, which provides a framework for access and benefit sharing. And it requires countries to designate ABS and prior informed consent focal points and compliance checkpoints, provides for internationally recognized certificates of compliance that a researcher could show, hey, I complied with this country's obligations, I entered a benefit sharing agreement, and this is great. And also it obligates parties to cooperate in cases of alleged violations of domestic benefit sharing or access legislation in a particular country. It doesn't require countries to set up a system where you have to require prior informed consent, but if you do, you need to follow the Nagoya Protocol provisions. But even with these provisions, there's a lot of flexibility, there's a lot of vague language. It's been called a masterpiece in ambiguity by one commentator. And it really just has floors and not ceilings. So we still see quite a bit of diversity and divergence in terms of the kinds of systems that countries are setting up within the constraints of the Nagoya Protocol. So something that has happened in recent years as we've had technological developments is we've seen the cost of sequencing DNA going down significantly, and sequences being uploaded to publicly accessible databases, and a concern that as researchers in some cases no longer need access to tangible material, that will bypass or allow for the bypass of the ABS obligations in the Nagoya Protocol. A way to illustrate this is to think about the wonderful mRNA COVID vaccines that have been developed. They were able to be developed in part because the SARS-CoV-2 virus sequence was posted online, and fairly quickly, Moderna, others were able to create a targeted sequence for a vaccine. And they didn't need access to tangible material to do this. Having the sequence information alone was enough. And we are seeing increasing amounts of sequence data being stored in and added to publicly accessible databases all the time, huge amounts. in part because when researchers publish their results, they're generally required by the publications to provide the sequence information to some publicly accessible database. GenBank is the one in the United States that is operated by the NIH, and it has a collection of publicly available DNA sequences, and it's just growing by leaps and bounds. And so the availability of the sequence information and the ability to bypass negotiating an agreement has led to a concern about a new kind of biopiracy, digital biopiracy, where sequence information from genetic resources in a particular country are uploaded to a database. Other researchers can freely use them without having to comply with any sort of access and benefit sharing agreements. And because the sequence really in many cases is what you need, and the ability to compare sequences with other sequences, which are also in GenBank and these other databases, you don't need the tangible material. An example of this is described by Ed Hammond in an article about the Ebola treatment developed by Regeneron, where they were able to access in GenBank the sequence of a virus strain from a survivor of the 2014 Ebola outbreak in the country of Guinea. And the Knox Institute had synthesized, sequenced the virus, uploaded it as the researchers were required to do when they were publishing their paper, and Regeneron was able to access that sequence from GenBank. Now, interestingly enough, if someone wanted to get a tangible sample of the virus from Knox, they would have to sign a material transfer agreement, which noted that the country of origin of the material is Guinea. The CBD requires users of genetic resources to share benefits with the country of origin. And basically, you've got to agree to this for the physical sample, but not for the sample in GenBank. No benefit sharing obligations are associated with that sequence that's in the database. So now Regeneron has developed this drug. It's patented in many countries. They received hundreds of millions of dollars in advance purchase commitments from the US government because Ebola was seen really as a threat to US interests. And the US government bought up all of Regeneron's production. They did make it available for free to the Congolese government in a recent Ebola outbreak, but it means that these countries are reliant on the goodwill, poor countries of the United States, even though the drug couldn't have been developed without the sequence information from African genetic resources. Now, this is complicated by the fact that Guinea, in fact, does not have, Guinea is a least developed country and doesn't actually have ABS legislation in place. But certainly, even without that, if someone had to sign an agreement like that material transfer agreement, Guinea could be a third-party beneficiary of that contract. So while there are so many concrete benefits from open access to digital sequence information or genomic sequence data, many different names for it, there's also this growing acknowledgement that these kinds of changes in research patterns, which are expanding the use of DSI in place of tangible material, threatens to undermine the bilateral scheme of the CBD and the Nagoya Protocol for benefit sharing. One of these technological areas is synthetic biology, where researchers are applying engineering principles to biology, looking at it as kind of modular, redesigning organisms to have new functions, possibly creating whole new organisms. And an example I like from science a few years ago is where researchers developed a morphine precursor, the bane, and they used genes from various different species, poppy, rat, bacterium, to get yeast to make these opiates. And that's an example of something that you can do with synthetic biology. Here's a patent application for a stevia substitute. Stevia is a non-caloric sweetener. And this patent involves the use of genes from around 30 different possible species, widely divergent species, in order to produce this non-caloric sweetener. And in the work that I did for the FAO, I was on a team, we interviewed a number of synthetic biology researchers, and this statement by one of them always has stuck with me. He said, you know, before we had to ask for the material if we wanted to repeat work that had been done in other labs, but now with synthetic biology and CRISPR, it's very easy, and we don't have to say anything to anybody. If someone published something interesting, I can use the data that was published, the sequence information, and do it very quickly. I can just type it on my computer, send it to a foundry, and the company is going to send me back the tangible sample of material with the sequence that I have specified. And that just gives this indication of how the bypass can take place. Now, there is this strong ethic of openness in the synthetic biology community, wanting transparency, open access to sequences. But nevertheless, folks are obtaining patents. They are choosing which information to make freely available and which to put under patent protection. And we're seeing this across many industrial areas, medicines, diagnostics, agriculture, you name it. So when we talk about DSI, what do we mean? This is an issue that came up, as I recall, in 2016 in the CBD Conference of the Party meetings in Cancun. The issue of DSI was on the agenda, and the CBD parties basically set up an ad hoc technical expert group to look at this issue, to look at a study that had been commissioned, and to try to come up with terminology and something that could be agreed on. I was a member of that ATEG, and we agreed on very little, unfortunately, except that DSI probably is not the right term, but it should be used as a placeholder in the meantime. Fortunately, more information was brought to bear, additional studies that I'll mention in a moment, and a second ATEG on DSI came out with a report in March of 2020 and said, well, DSI could be considered DNA and RNA, or DNA and RNA and proteins plus other epigenetic modifications, or you could go even further. These are ways that you can look at this. This is not an issue that has been decided because the Conference of the Parties meets every 2 years and was supposed to meet in 2020. Pandemic prevented that. And so now maybe it will be 22, we'll see what happens with the pandemic moving forward. But that's something that will be on the table to be decided. What are we talking about when we're talking about DSI? How broad is the group? Should a different terminology be used? And to get to that report, the meeting of the Conference of the Parties in 2018 in Sharm el-Sheikh, Egypt, commissioned 4 studies, or at least provided for the commissioning of 4 studies on how DSI is used, traceability in databases, what are countries doing in national law to address benefit sharing from DSI. And I was the lead author on that particular study. And then there was another study to identify specific cases of genetic resources and traditional knowledge that occur in transboundary situations or where it's not really possible to grant consent. And DSI falls into that category, at least arguably. And that was another study that I was involved in preparing, and that was to inform these deliberations that hopefully will be taking place later this year. One of the big questions is whether DSI is even within the scope of the CBD or the Nagoya Protocol, because when you look at the definitions in those agreements, genetic resources means genetic material, and material sounds tangible, and DSI is information. So that's a question. But the agreements also talk about benefit sharing applying to the utilization of genetic resources. And DSI results from the utilization of genetic resources. And then we've got this definition of biotechnology. So we have the possibility of DSI being within the scope of the CBD and Nagoya Protocol, but it's complicated. And part of the reason why it's complicated, part of the reason why some parties are arguing that it's not within the scope is because of how challenging it has been to implement the Nagoya Protocol for tangible genetic resources. It takes a lot of time, it takes a lot of money. Many countries are under-resourced in terms of even having the capacity to create these kinds of legal structures. The EU implemented the Nagoya Protocol very quickly with a regulation that requires due diligence of users of genetic resources. And yet these users need to show that they've complied with the legislation of a particular country. And in many cases, that legislation is not in place yet, or it's a very long and drawn out process to negotiate an agreement. This study that was done for the EU Commission, I believe, said it can take between 500 to 10,000 euros per negotiation, up to 500 personnel hours, up to 3 years to conclude. It's a lot, and that's for tangible genetic resources. So when people started talking about DSI, there was very strong resistance to bringing that into the CBD and Nagoya Protocol negotiations as well, not surprisingly. So what we've seen in this area, or what I've categorized as 3 views of DSI and the CBD. With view 1 being the DSI is not within the definition of genetic resources, but it can result from the utilization of genetic resources and can be addressed in mutually agreed terms. If a researcher is negotiating with a country about access to tangible genetic materials, the country can put in place restrictions regarding DSI that's generated from those genetic resources at that time. But that basically should be it. Because DSI itself is a global benefit really to humankind, and no further benefit sharing for its use should be provided. If you think again of the COVID vaccines, this helps all of us to have sequence information like that freely available. The second view is that the definition of genetic resources should be interpreted to include DSI so that it is subject to prior informed consent and mutually agreed terms under the Nagoya Protocol. And countries that are adopting this view will, in some cases, have access limitations on tangible genetic resources because that's where the DSI will ultimately come from. And then view number 3, which for reasons I'll discuss, I think is a superior view, is that DSI is not within the definition of genetic resources, but it does result from the utilization of genetic resources. So it is within the scope of the Nagoya Protocol, but that doesn't require access limitations, shouldn't be any prior informed consent requirements for information that is in these publicly accessible databases, but there should be the sharing of benefits from commercial uses, monetary benefits and non-monetary benefits. DSI's intrinsic non-monetary benefits are not sufficient to comply with the Nagoya Protocol's requirements. So to say a little bit more, this is, I think, a great example of this view number 1. This is from a paper, a statement that was put out by public and private sector organizations, academic and scientific institutions, a broad range of stakeholders, pointing out how important it is for there to be unencumbered access to digital sequence information because it benefits countries at all levels of development, benefits the public population as a whole, and it's basically in the public domain, and this open sharing represents a form of non-monetary benefit sharing. I call this, excuse me, view, what's yours is mine, and what's mine is mine. I can use your resources, DSI, not genetic resources, but your resources, and not share any monetary benefits I make from them with you. So this view doesn't really consider the claims of owners of genetic resources as on a par with owners of other types of research inputs, such as patented inventions. If you think about it, lots of things are beneficial that are protected by patents, and the owners of those patents still expect to be compensated and can sue for infringement if they're not. And the fact that it's in the public domain, well, the public domain is a construct. it's a national construct, and what is in or not in the public domain varies by country. And just because something is publicly available doesn't mean it's not protected by an IP right. You can think of music, you can think of the disclosure of information in a patent. And in fact, GenBank on its website states that it places no restriction on the use or distribution of the data. However, some submitters may claim patent, copyright, or other IP rights in a portion of the data they have submitted. Also, DSI doesn't benefit everyone equally. Everyone doesn't have equal access to the fruits of DSI or even the ability to work with it. And I like this picture that I found in The Economist, and the statement from someone at the Brookings Institute, how the lack of access to electricity or reliable electricity constrains the ability of many researchers in poor countries, low and middle income countries, to adopt emerging technologies. And so that's something that we have to think about in terms of the fact that the playing field is not level. And this goes to ideas of justice and fairness as well. So open sharing of DSI is a non-monetary benefit, but it's not enough, this generalized non-monetary benefits. And that's what many provider countries are saying. There is indeed a lot of effort and invention and funds that go into transforming the sequence information or the tangible resources into something like an mRNA vaccine. But that doesn't justify an absence of benefit sharing. That should go rather to the amount of benefits that need to be shared, not whether any should be shared at all. View number 2. So this is the idea that DSI should be considered within the definition of a genetic resource. And when you take that view, you're likely to put access limitations, or more likely to put access limitations on DSI, and that is problematic. That could hamper scientific developments. If you think about trying to negotiate bilaterally, the speed that's required as science is moving forward, 3 years to negotiate a benefit sharing agreement. And as I pointed out, when we're dealing with sequence information, you may be using sequences from many different organisms. And the idea of trying to negotiate each one doesn't seem practical. So the fact-finding study we did on how domestic measures address benefit sharing arising from commercial and non-commercial uses of DSI, we found that 16 countries are already putting in place or have in place domestic measures addressing DSIs. Some of them actually do interpret genetic resources to include DSI and may put access restrictions in place. Some of them may prevent patents from issuing on inventions where prior informed consent was not obtained, or imposing other kinds of penalties on researchers that maybe you cannot market products in that country, or other countries that see their Nagoya Protocol obligation to cooperate with countries that have this kind of legislation. And I've got the names of those countries there. It's all in the study. And I call this view, what's mine is mine, the genetic resources in DSI, and what's yours is mine, the money that you make from DSI-based products. So this view is also problematic because you can have overreach on the part of provider countries seeking control and perhaps a disproportionate share of the value of the utilization. Any one particular sequence may not have much value. Its value is in its aggregation and the fact that you can compare it with other sequences and find out what is different. And that is often what allows researchers to develop new and wonderful products. So these two views are both problematic, and in a sense, they are opposite ends of a rope on which tug of war is being played. There is another approach, however, and that is actually alluded to in the Nagoya Protocol itself, the possibility of a global multilateral benefit sharing mechanism. And Article 10 of the Nagoya Protocol says that parties shall consider the need for modalities of a global multilateral benefit sharing mechanism to address the sharing of benefits in situations where the bilateral approach really is not practicable. And this seems like, well, this could be a solution, but there's a lot of resistance to this idea as well. And part of the resistance is, I do believe, due to industry experience with implementation of the Nagoya Protocol in relation to tangible genetic resources. And the idea is let's just keep it outside and not deal with DSI at all in relation to this agreement. So researchers from academia, from corporations wanting to avoid additional complex benefit sharing obligations. But this is a problem because benefit sharing matters. It is important. It matters to issues of justice. It issues to matters of self-interest. And that's something that it's generally good to appeal to. If we see countries limiting access to tangible genetic materials, part of the reason why that is a problem is because there's so much biodiversity that has yet to be characterized to see what its potential is for medicinal or other applications. Fewer than 15% of higher plant species have been examined, fewer than 1% of microorganisms are easily cultured. So we don't want to countries to put access limitations on these materials. Many drugs that we have came from natural products, and we can expect that many more will come from natural products. At the same time, biodiversity is under threat. A recent UN report pointed out that 1 million species face extinction unless something is done to address the drivers of biodiversity loss. And something they noted that if preserving land in its natural state is not sufficiently lucrative, it will be put to a different use, adverse to biodiversity conservation. Well, the folks who tend to steward the land and the plants in their natural state are Indigenous peoples and local communities, IPLCs. They safeguard 80% of the world's remaining biodiversity, but they are some of the most disadvantaged members of our global society. They account for about 15% of the extreme poor, lower life expectancy, and yet they are doing so much to preserve biodiversity for all of us. And sometimes there is a disconnect between the idea of this sequence information and what traditional knowledge or traditional knowledge holders may have to do with that. But they're not necessarily just living in the forest. They have been modifying and interacting with the natural environment for millennia. They will, in some cases, develop and impose strict harvesting protocols for medicinal plants, impose boundaries to protect growth areas, set controlled burns to keep massive fires from taking place, which would destroy much more biodiversity. So they are stewards, active stewards of biodiversity, and need to be rewarded and incentivized to continue to preserve biodiversity. I have an example in the paper about a place in Australia where the Anangu people lived. They were driven from Uluru, and they had been engaging in the controlled burns that allowed for species to survive and thrive. Once they left, massive fires took place. Only 25 of 46 mammalian species that were known to exist remained. And it is attributed to these changes to the traditional fire regimes and the fact that folks were not there. Benefit sharing can also create economic development opportunities for communities through appropriate exploitation of knowledge about genetic resources. And this is an example of a study I did for the Center for International Governance Innovation, looking at South Africa's Council for Scientific and Industrial Research and the role that they play in valorizing traditional knowledge, working with holders to do clinical studies, to validate their knowledge. In this particular case, they found an industrial partner for these communities, the Maswanganyi and Mabunda communities. They helped them to set up a plant to process the plant that grows very well in this particular area of the Limpopo province. And it's created jobs. It's providing money for education, for food. It is a wonderful example of how providing benefits, monetary benefits, can result in economic development that can also be sustainable for the biodiversity in the area. So a lot of things to think about, and I'm trying to wrap up so that we will have time for some questions. In negotiations, or at least discussions that have been taking place since the last meeting of the CBD Conference of the Parties in 2018, various folks have put out proposals for a framework. How do we figure out what a global multilateral benefit sharing mechanism might look like? Well, for one thing, it needs to have open access to digital sequence information in publicly accessible databases. It needs simplicity and legal certainty. It needs to actually work. We probably need to retain the bilateral approach for physical genetic resources at a minimum in the short term. And as I was just mentioning, there needs to be flexibility in the use of funds received from benefit sharing for economic development in some cases. And there needs to be a differentiation between non-commercial versus commercial research, and looking at solutions that impose the same kind of costs on both could be problematic. And we need interest convergence, in the words of Derek Bell. The interests of both sides would need to converge in a way that provides each with a just outcome. Most recently, in June of last year, the African group put forward a proposal, and this was in the CBD subsidiary body on implementation third meeting, proposing that developed countries should take measures to ensure that 1% of the retail price of commercial income resulting from utilization of genetic resources, traditional knowledge associated therewith, or digital sequence information is shared through some sort of multilateral benefit sharing mechanism. So taking a small amount of the use of genetic resources to fund this mechanism, along with the use of appropriate non-monetary benefits, that could be a way to support all three goals of the Convention on Biological Diversity with Conservation, the sustainable use, and the fair and equitable benefit sharing. It's good. That's just a proposal to give you an idea of what it might look like. There's going to be a lot of negotiation before we get to that. But to conclude, we have seen a lot of technological developments that are changing the way genetic resources, sequence information are being used. And it is allowing researchers to bypass the Nagoya Protocol and raising concerns about digital biopiracy. And these sequences did originate in tangible genetic resources that were stewarded and preserved, and in some cases even cultivated by Indigenous people and local communities. And justice requires the sharing of the fruits with those original contributors. Not just justice, but it's on our own benefit to make sure that access to those resources remains available, the resources remain available, and access remains open. And it is possible that a global multilateral benefit sharing mechanism could be crafted that could address many of the issues on both sides and inject justice into a system that currently lacks it. And with that, I thank you for your time, and I will stop and will gladly take questions.